Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. Our today's topic of discussion is maintenance under Parsi Law. My dear learners, you will learn about the following things from the present module. Firstly, the introduction about the topic, then meaning and objective of maintenance, basis of the concept of maintenance in India, then maintenance under Parsi Law, then relevant provisions of the Parsi Marriage and Divorce Act 1936, quantum of maintenance, alteration of the amount, maintenance of children and parents under Parsi Law, and also maintenance under section 125 of Criminal Procedure Code. And lastly, we will discuss the concluding part. First of all, let's have a brief discussion about the subject matter at hand. Maintenance has been a concern not just for the weaker sections, but of society as a whole. When one, despite having sufficient means, fails to support his dependents, then such concerned persons are forced to seek state's assistance or else take a career detested or prohibited by the society, which goes against the interest of the society. Thus, the object of maintenance is to prevent immorality and destitution, as well as to ameliorate the economic condition of women and children in general. It is every spouse's duty to maintain the other one who is financially dependent on them. Every law, irrespective of the fact that it may be the Hindu law, Parsi law or the Christian law, has provisions for the maintenance of the wife as well as the children. The concept of maintenance in India is covered both under section 125 of the CRPC as well as the personal laws of various communities. While the provisions of the personal laws of the parties are related to the religions of the concerned parties, the provisions of section 125 of CRPC are applicable to all the citizens of India, irrespective of their religion. For example, a Hindu wife can claim maintenance under the Hindu Adoption and Maintenance Act 1956, while a Parsi wife may seek relief under the relevant provisions of the Parsi Marriage and Divorce Act 1936. In the present module, the concept of maintenance under Parsi law will be discussed in detail. Let's begin with meaning and objective of maintenance. As we have discussed earlier also, maintenance can be defined as the periodic monetary sum paid by one spouse for the benefit of the another on separation or on dissolution of marriage. It is also referred to as alimony or spousal support. It also means the amount payable by a parent to his child for his personal living expenses, and also means the support one person is legally bound to give to another for their survival and basic living. The right to maintenance comes from the concept of undivided family, where the head of such a family is bound to maintain the person who is not financially independent to make a proper living and capable of enjoying the basic necessities of life that he or she is reasonably expected to enjoy. The whole concept of maintenance was introduced to make the living of such a person possible and independent. Let's discuss what is the basis of the concept of maintenance in India. Under Indian law, generally, the term maintenance includes an entitlement to food, clothing and shelter, generally available to wife, children and parents. The concept of maintenance is intended to fulfill a social purpose. However, we must remember that the idea of social justice can also be found in the preamble as well as Article 21 of the Constitution. These provisions seek to ensure that the neglected wife and the children are not left destitute and starved. Therefore, the Indian Parliament, in its desire to find a solution to this problem, evolved a procedure that has found expression in Chapter 9th of the CRPC. The basis of the concept of maintenance can be further found in Article 15, Clause 3, which is reinforced by Article 39 of the Constitution. It is pertinent to note that Article 15, Clause 3 empowers the state to make special laws for the welfare of women and children. Article 39 of the Constitution states that the state shall, in particular, direct its policies towards securing that the citizens, men and women equally, have the right to an adequate means of livelihood, that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that the childhood and youth are protected against exploitation and against moral and material abandonment. Now let's discuss maintenance under Parsi law. The Parsis are an ethno-religious minority of the Indian subcontinent who practice Zoroastrianism. They descended from Persians who relocated to medieval India to maintain their Zoroastrian identity during and after the Arab conquest of the Persian Empire. In comparison to Iranis, whose forefathers migrated to British ruled India from Khazar era Iran, the Parsis are the oldest of the Indian subcontinent's two Zoroastrian populations. According to 16th century Parsi epic Kissa-e-Sanjan, Zoroastrian Persians continued to move from Greater Iran to the Indian subcontinent between the 8th and the 10th centuries, eventually settling in the present-day Gujarat after being granted asylum by a local Hindu ruler. Parsis can claim maintenance from the spouse through criminal proceedings or civil proceedings. Interested parties may pursue both criminal and civil proceedings simultaneously, as there is no legal bar to it. In the criminal proceedings, the religion of the parties doesn't matter at all, unlike the civil proceedings. If the husband refuses to pay maintenance, the wife can inform the court that the husband is refusing to pay maintenance, even after the order of the court. The court can then sentence the husband to imprisonment unless he agrees to pay. The husband can be detained in the jail so long as he doesn't pay. Let's discuss in detail the relevant provisions of the Parsi Marriage and Divorce Act 1936. The provisions contained in the Hindu Marriage Act 1955 and the Special Marriage Act 1954, especially relating to the custody, maintenance and education of children, were actually first made under the Parsi Marriage and Divorce Act. The language of the provision under the three laws is nearly identical. All of them provide safeguards for the interest of the children likely to be affected through provisions under matrimonial remedies, if granted under the relevant law. The Parsi Marriage and Divorce Act 1936 speaks about the right of the wife to maintain both alimony pendent light and the permanent alimony. What is alimony pendent light? It is also known as interim maintenance. Section 39 of the Act provides for the relief of alimony during the pendency of any proceedings under the Act. It states that if any suit is filed under the Act and it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the suit, it may, on the application of the wife or the husband, order the defendant to pay to the plaintiff such expenses for the purpose of carrying on the suit and such weekly or monthly sum during the pendency of the suit as having regard to the plaintiff's own income and the income of the defendant, whatever may seem to the court to be reasonable. It is to be noted that this section didn't exist in the original Act, and it was only inserted by the amendment of 1988. Hence, both the spouses are entitled to claim maintenance under the Parsi Law. Only requirement being that he or she has no sufficient means to support himself or herself. Further, it is provided that application for maintenance and expenses shall be, as far as possible, disposed of within 60 days from the date of service of notice on the wife or the husband, as the case may be. It is also pertinent to note that provisions of Section 39 of the Parsi Marriage and Divorce Act and Section 36 of the Indian Divorce Act are similar to Section 24 of the Hindu Marriage Act. Permanent alimony and maintenance. The relief of permanent alimony is provided under Section 40 of the Parsi Marriage and Divorce Act. It states that at the time of passing any decree or at any subsequent time thereto, the husband or the wife, as the case may be, shall file an application for her or his maintenance and support, such gross sum or such monthly or periodical sum for a term not exceeding the life of the plaintiff. What will be the quantum of maintenance? While fixing the quantum of maintenance, the court shall consider following factors: defendant's own income and property, plaintiff's income and property, also the conduct of the parties and any other relevant circumstances which may seem to the court to be just. In order to secure the payment of alimony and maintenance under this section, it is also provided that the amount of maintenance will be a charge on the movable or immovable property of the defendant. Then, whether such amount can be altered or cancelled in future, then the answer is yes. The amount of maintenance once fixed under Section 40 Clause 1 can be increased, decreased or even rescinded in such a manner as the court may deem fit at the instance of either of the party. Such alteration or cancellation of maintenance may be done in the cases where there is a change in the circumstances of either party at the time after the order has been made under the relevant section, or in case the court is satisfied that the party in whose favor an order of maintenance has been made has remarried, or if such party is the wife and she has not remained chaste, or if such party is the husband, then he had sexual intercourse with any other woman outside the wedlock. The Act provides for payment of alimony to wife or to her trustee. According to the provisions of Section 41, in all cases in which the court shall make any decree or order for alimony, it may direct that the same shall be paid either to the wife or it can be paid to any trustee on her behalf. But such trustee has to be approved by the court. Such amount can be paid to a guardian also appointed by the court. It is to be noted that the provision relating to the payment of alimony to a guardian appointed by the court was inserted through the amendment of 1988. The court is empowered to further impose any terms or restrictions also which to the court may seem expedient. The court may also from time to time appoint a new trustee or a new guardian, if for any reason it shall appear to the court expedient to do so. It is worthwhile to note that the provisions of paying maintenance to the wife or to her trustee is also provided under Christian law. However, beside the Parsi law and Christian law, such provision is not provided under any other personal law and even under section 125 of the CRPC. The Act also provides for the disposal of joint property. Section 41 states that in any suit under this Act, the court may make such provisions in the final decree as it may deem just and proper with respect to the property presented at or about the time of marriage, which may belong jointly to the spouses. My dear learners, we must remember that the suits under this Act regarding matrimonial remedies are to be heard in camera and may not be printed or published. Section 43 mandates that every suit filed under the Act shall be tried in camera. That is, it shall not be open to the general public, and it shall not be lawful for any person to print or publish any matter in relation to any such case except a judgment of the court, printed or published with the previous permission of the court. Further, it is provided that if any person prints or publishes any matter in contravention of these provisions, he shall be punishable with fine which may extend to 1,000 rupees. It is important to note that the present section 43 has substituted the provisions of the previous section. Now let's discuss about the maintenance of children and parents under Parsi law. Under the Parsi and the Christian laws, there are provisions for the custody, maintenance, education, etc. of the minor children, which are similar to the Hindu law, even though there is no specific provision for maintenance, unlike the Hindu Adoption and Maintenance Act 1956. However, it is important to note that under these personal laws, the maintenance of the minor child can be awarded only during the matrimonial proceedings and not otherwise. Similarly, in case of maintenance of parents under the Parsi and the Christian laws, there is no provision imposing an obligation upon the children to maintain their aged parents. The parents who want to seek maintenance can do so only under the section 125 of CRPC. Let's discuss an important case law, that is Firozshah Bharucha versus Hirabai Bharucha. It is a case of 1945. In this case, the issue that came up before the court was whether the wife after the dissolution of marriage can give up her claim to future alimony. The petitioner in this application asked for fixing of maintenance by the court under section 40 of the Parsi Marriage and Divorce Act. The respondent filed a suit for divorce against the petitioner, and the petitioner had filed a counter claim for the same relief. The husband not having pressed his suit, the counter claim was decreed and the petitioner wife was granted a divorce decree. After the decree for divorce was passed, parties arrived at certain consent terms in connection with the custody of the children, permanent alimony, as well as provisions for the maintenance of the children, and the said terms were set out in a consent order. One of the terms of the consent order was that the defendant wife agreed not to claim alimony at any time in future. The petitioner wife, however, later filed an application before the court on the ground that at the time when the consent order was made, she was being helped by her brother, who maintained her apart from her own income by personal exertion to maintain herself. But now that support of her brother has ceased, and she applied that the court should fix maintenance for her. The husband argued that the parties ceased to be husband and wife after the passing of the divorce decree, and subsequent to the dissolution of their marriage, there was a consent order passed by the court, to which both the parties had agreed. The husband further argued that the consent order between the parties and the consent decree between the parties should be set aside only on well-known grounds, and therefore there should be first a proceeding to set aside such a consent decree or the consent order before the court can grant maintenance to the wife. A consent decree between the parties is a contract between the parties which has been recognized by the court, and as such it will stand as a contract. The question here is whether such a contract, namely the wife giving up her claim to alimony altogether, is a valid contract. In other words, it is a voidable contract or a void contract. If it was a voidable contract, the court would not entertain this application unless the contract has been avoided by a proceeding to set aside the consent order or the decree. Here, the court quoted Lord Atkin's observation that the wife's right to future maintenance is a matter of public concern, which she cannot barter away. In the light of this statement, the court observed that the wife could not barter away such a right and enter into a contract to that effect, so that such a contract would be a void contract in the eyes of the law. The court held that a particular part of the consent order is not at all a bar to the present application filed by the wife for fixing her alimony under the Parsi Act. Besides these provisions of Parsi law, a Parsi wife, children or the parents can also claim maintenance under section 125 of the CRPC. Although Criminal Procedure Code is a procedural enactment, it also confers some substantive rights, the right of maintenance being one of the most important of such rights. Legal provisions regarding order for maintenance of wives and children are mentioned under Chapter 9, Section 125 to 128 of the CRPC. Section 125 of the Code gives effect to the natural and fundamental duty of a man to maintain his wife, children and parents, so long as they are unable to maintain themselves. This provision is a measure of social justice and was specially enacted to protect women and children. Hence, the nature of provisions under Section 125 of the CRPC is social justice legislation, and it is to be construed liberally for the welfare and benefit of the wife and the children. Section 125 of the Criminal Procedure Code provides that any person who has sufficient means to maintain himself cannot deny the maintenance to the wife, children and parents if they are not able to maintain themselves. The court, after the party has invoked Section 125 of the Code, may order the respondent husband to maintain the wife who is unable to maintain herself by providing monthly maintenance to her. However, there is an exception to the provision. For the purpose of providing maintenance to the wife, the husband has to be sufficient enough to support his wife after the separation, and at the same time, the wife must not be living in adultery or living separately from her husband without any sufficient cause. Even if they are living separately in mutual consent, then also the wife will not be entitled to any sort of maintenance. Whenever the judgment is passed in the favor of wife, the court has to make sure that the husband has sufficient means to provide maintenance to the wife. The court also needs to make sure that the wife after the separation doesn't have enough money to maintain herself. We must also remember that under the present times, a husband may also claim maintenance from his wife if she is having sufficient means. From the above discussion, my dear learners, it is evident that maintenance plays an extremely important role in matrimonial matters. This has been even more relevant in today's times when people undergoing divorces who are financially dependent on their spouses have to run from pillar to the post in order to make both ends meet. Therefore, the matrimonial courts in the country hold a position of great responsibility of granting maintenance to aggrieved spouses. Undoubtedly, the Parsi law also contains adequate remedies and provisions to provide maintenance to the women and the children. With this, we come to the end of today's lecture. Thank you very much.